If you are negotiating or litigating against Oracle or NetSuite, there is a case that needs to be on your radar. Realscape v. Oracle. That's what I want to unpack today. My name is Marcus Harris. I'm a software and technology attorney. For over 20 years, I have drafted and negotiated software-related contracts and litigated failed software implementations in courts across the country. So what is this case about? Well, at a headline level, Realscape or Realogic, they're doing business as Realogic, is a NetSuite failed implementation case that deals in hidden terms and is a putative class action. And the customer here has made allegations that the NetSuite software was sold off the shelf. Cloud ERP would be fully implemented. Oracle made this representation. The cloud ERP would be fully implemented and integrated by a date certain, July 1st, 2023, and it just didn't come to fruition. But what is interesting about this case, and I think why it needs to be on your radar really, is Realogic is attacking the entire hyperlinking scheme that Oracle utilizes in its contractual framework. It's a framework that's utilized by most other vendors as well. And so here, Realogic argues that there was no mutual assent to the online SSA terms. These are the software subscription agreement terms that were actually hyperlinked. And then once you hit the hyperlink, it led you to an Oracle page with a whole bunch of drop downs, and you had to figure out which contract was applicable to your deal. And there's a variety of different contracts on these pages. The allegation essentially is that key clauses related to the relationship were effectively hidden, and that the whole architecture is essentially, this whole contract architecture is really a bait and switch scheme to get you to agree to onerous provisions without realizing that you're agreeing to them. So what makes this case interesting is that Realogic is attacking the entire contractual framework that Oracle utilizes. And remember, if you've dealt with Oracle in the past, they love to hyperlink to provisions and policies and substantive terms and conditions that are not included in the document that they're actually showing you. And the way they operate is they give you an order form that looks relatively simple, but incorporates by reference maybe 10 URLs, and each one of those URLs, once you find it, click on it, and open it up, is anywhere from 10 to 20 to 30 pages of substantive terms and conditions that govern your relationship with Oracle. And here, Realogic argues that because of that scheme, there was really no mutual assent to those online SSA terms, the software subscription agreement terms, and that the key clauses that govern that relationship were effectively hidden, and that the whole architecture, the contractual framework that Oracle utilizes is really kind of this bait and switch. And I think you've got to understand that this is not just an Oracle thing. This is the way SAP operates. This is the way a variety of other vendors operate. How does that Oracle structure work? And I think to understand the leverage that this case creates for you, if you're litigating or negotiating against Oracle or NetSuite, you've got to understand the contractual architecture that Oracle relies on. And so first, they give you an estimate or an order form. It's usually titled as an estimate. And this is almost always some sort of a DocuSign agreement labeled estimate that sets out the products, the terms and the fees. And then somewhere on the last page of this agreement in relatively small print, it's going to say, that the products and services are governed by the subscription services agreement or the software services agreement, followed by a number of bare hyperlinks, and that, that single sentence is really the only indication that they're trying to pull in these other terms and conditions. The second document in this contractual framework or architecture really is the statement of work with the SOW, and there's typically a separate SOW for each work stream. You've got financials, HR, you've got payroll. In these documents lay out the scope, tasks, and responsibilities, and those SOWs contain their own integration clauses expressly disavowing any reliance on prior proposals or communications, which Oracle uses to argue that any pre-contract sales promises are not part of the deal. And again, that's a fairly common maneuver in any contract. But here, I think because of the nature of the hyperlinked structure, it becomes particularly important. Third is the subscription services agreement, or the SSA. You don't see this document in the DocuSign packet. And to get it, you've got to click on or click through that hyperlink, which takes you to a generic Oracle NetSuite Cloud Services Contracts landing page with a variety of options. You can kind of try to pick which contract might be applicable to you. Core point is that Oracle never actually provided the SSA or clearly identified which version of the SSA applied, and that nothing in the DocuSign flow required or evidence that the customer was actually assenting to the SSA. So I think if you look at Realogic's opposition brief with respect to this hyperlink structure, it's really kind of a mini playbook on how to attack hidden web linked terms, especially under Ohio law, but with broader U.S. authority that many courts could potentially find persuasive. I mean, first, this incorporation by reference, and the law generally requires that for external terms to be incorporated, the contract's got to identify those external documents reasonably and beyond, I wouldn't say a reasonable doubt, but they've got to be identified with some level of particularity, and Realogic argues that the reference is just too vague. Second, they argue this concept of reasonable notice. And I think courts are increasingly skeptical of terms that are buried in conspicuous hyperlinks or in what they often call browse wrap or hybrid wrap structures where the user is never forced to affirmatively agree. And so Realogic cites a variety of cases with respect to that issue. There's no final adjudication of the case. And so in some ways, we don't really understand how this is going to turn out. But I think, if you read the tea leaves from the parties' briefing and from how other similar online term cases have played out, Oracle leans heavily on standard Sixth Circuit, Ohio, and Ninth Circuit authority, enforcing forum selection clauses and online terms where the parties are commercial entities, and there is at least some reference to the governing agreement. This case was removed to the forum that Oracle preferred, which is in Northern California. And so, I mean, I think when you look at that, I think that's kind of an indication of how at least the Ohio court was viewing all of this. And you say these are sophisticated entities, they're businesses, and certainly that Realogic had the time and the capacity to be able to understand the contract that it was signing, and that really it probably should have taken the time and done the due diligence not to get itself into this situation. What are some of the takeaways from this? And I think that's where the real value is. And it's, how does this impact you when you're negotiating with Oracle or with any ERP vendor that is incorporating hyperlinks into its contract package? And I think, first, you want to make any of these hyperlinked terms explicit. You want to essentially kill any kind of floating hyperlinks. You want to make sure that there is no unilateral ability by that vendor to modify the documents that are at those links. You want to make sure that you know what contract is a part of the package. It needs to be explicit. If you're really having an issue with any of the terms, I mean, you're going to want to make sure that you negotiate them and you push back on them. That simply just makes sense. I mean, again, you've got to understand what you're signing, and Oracle's not going to be your friend in this scenario. And, again, it's kind of this pattern of trying to make everything look easy and simple and less complicated than it really is. And if you're getting a 4-page document that's easy to understand, then on the last page in small script, it references 10 to 15 hyperlinks. You need to know that, and you need to make sure that each one of those, if they're not printed out and attached as exhibits to the agreement, that you've got language in there that accounts for that those are incorporated by reference, and that to the extent they're going to be changed unilaterally, they can never contradict the terms of this agreement. Or, if they're going to contradict the terms or be different than the terms, that none of the obligations are going to be diminished, and certainly any kind of functionality is going to be at least as good as what you're getting today. And I think those are, for me, are the real takeaways from this case, and those are the things that you want to be on the lookout for. If you have any questions about anything I've talked about in this video, any tips or tricks that we would utilize in negotiating with Oracle, NetSuite, or any other vendor, please feel free to reach out to me. I'd love to talk to you and get you pointed in the right direction.